To buy land or property in the UK, you need to find the deal you want, make an offer, have the seller accept that offer, go through the conveyancing stage, get a mortgage, exchange contracts, and register the title of your property. Step by step, this involves firstly searching for a property using an online real estate portal. To search for residential properties, the most popular websites are Rightmove, Zoopla, and On the Market. To search for land, the most popular websites are Plot Finder, Add Land, and the UK Land Directory. To search for agricultural land, the most popular websites are UK Land and Farms, Rural Scene, and Land Watch. To search for land auctions, the most popular places are Alsop, Savills Auctions, and Auction House UK. Real estate agents also post listings on their website, and you can go to them directly to see what properties they sell. Alternatively, you can buy from a private seller by contacting the existing owner of a property. To contact a private seller or estate agent, you email them or phone them, asking some questions about the property and if you can book a viewing to see the property in person. Booking a viewing isn't mandatory, but it is common practice when buying a house. Once you have viewed the property, you may have specific questions you want to ask, such as if the property is connected to utilities, if there are any faults with the property, and if there are any restrictions attached to the land. Once you are happy with the property, you can make an offer which either matches the asking price or is lower, where you negotiate the price with the seller. The estate agent will then pass this offer onto the seller, who either negotiates the price with you or accepts your offer. If the seller accepts your offer, then a memorandum of sale will be sent, which is a non-binding document confirming the parties' intentions for a property transaction. It should include the name of the parties, address of the property, and the agreed sale price. Standard templates for a memorandum of sale can be found online. Once this memorandum of sale is sent, the process moves on to the conveyancing stage. The conveyancing stage is the name for the legal process to transfer the ownership of property. You don't have to have a lawyer in order to buy and sell land, but it is common practice in the UK to do so. To get a lawyer to help carry out the conveyancing process, you can either get a solicitor who is a qualified lawyer with the power to complete the conveyancing process on your behalf, or you could get a conveyancer who is a property law specialist that is licensed to undertake conveyancing. A lawyer may be recommended by an estate agent, or you can get your own independent lawyer. During the conveyancing process, your lawyer will check the title of the property, obtain searches on the property, draft the contract of sale, inquire about the property, help secure a mortgage, exchange contracts with the seller, and register the title of the property. Checking the title of the property is necessary to make sure that the seller is the true owner of the property, so you are not buying land from a fraudulent person. To check the title register of a property, you must go to the gov.uk website, search for land and property information. Using the property's address or location, you can access the title register of a property to receive the title number of the property, the name of the owner of the property, how much the owner paid for the property, if there are any restrictions or easements attached to the land, and whether there is a mortgage on the property. You can also access the title plan of the property to receive a rough boundary of the property. To access the online copies of the title register and title plan, you need to make an account with HM Land Registry, then pay £7 for each document. On the title register, there may be easements or restrictive covenants. These are rights which others have over your land. An easement allows another person to use your land for a specific reason, such as a person may be able to walk over your land without you being able to prevent them from doing so if they have an easement for a right of way. A restrictive covenant prohibits you from using your land in a certain way when previous owners of the land agreed to make a restrictive covenant, such as a prohibition to build on the land due to a restrictive covenant. The title register also shows if there are any mortgages, known as charges, over the land. Once you buy land from the seller, any mortgages must be paid off before the land is truly yours. Most people, when buying a property, require a mortgage. A mortgage is a loan usually given by a bank which is used to help purchase a property. Usually buyers should apply for a mortgage after their offer for a property has been accepted, and the mortgage should be approved before the contracts are exchanged. When a buyer applies for a mortgage, the lender will check the buyer's financial situation to make sure that they can pay off the loan. But after the buyer gets a mortgage offer, most lenders require the buyer to obtain certain property searches before they approve the mortgage. There are three main searches that a lender requires, being a local authority search to check for planning permission or building regulations, an environmental search to identify a risk of flooding or contamination, and a water and drainage search to confirm that the property is connected to the mains water and sewage systems. These checks aren't necessary if you are buying the property outright in cash, but they are necessary if you're using a mortgage to buy the property, since most lenders require these three searches to be complete before sending over the money to pay for the house, as they want to know that their investment is safe. There are other optional searches which can be obtained, such as mining searches or chancel searches, but the three main searches a lender usually requests are a local authority search, water and drainage search, and environmental search. A local authority search shows if your property is affected by planning permission or if there are any proposals for new roads which could affect your property. There are two documents relating to local authority searches. There is an LLC1 search to search a local land charge register held by your local council containing the details of all charges registered against the property within a local borough, including financial charges, planning permission and enforcement notices. The second search is a CON29 search, which contains any proposals for new roads, highways or rail schemes that could affect the property. There is also a CO290 search, which is an optional search, which is a wider search that is only relevant to certain types of properties. To obtain a local authority search, you can order one at your local council's website and pay the appropriate fee. An environmental search provides information about the contamination of land, risk of flooding, risk of landslips, and more. To get an environmental search, you must go to an environmental search provider, such as Groundshaw or Searchflow. A water and drainage search confirms that a property is connected to a public water system and sewer. You can obtain a water and drainage search from a water and drainage search provider, such as Searches UK, or your local water supplier, such as Thames Water, Severn Trent, or Southern Water. These three searches are most likely to be requested by your lender before they send the mortgage payment through. But there are also other optional searches you can get to make sure the property isn't affected by other issues, such as a mining search to determine if local mining activities affect the property, or a chancel repair search to see if the homeowner owes a duty to pay for repairs to a local church in the area. If you are unable to get one of the searches you need for your property, you may need to take out indemnity insurance to insure against any financial loss which could be caused by any legal issues resulting from the missing search. Whilst the buyer's solicitor is conducting the title search and property searches, the seller's solicitor should draft the contract of sale. The contract of sale is the legally binding contract outlining the terms of sale. The contract of sale should include the buyer and seller's names and addresses, the property address and title number, the title register and title plan, the sale price and deposit amount, and the completion date. The completion date is the date where the property is formally transferred to the buyer. Contracts of sale should also include standard protocol forms which are required by the Law Society in contracts of sale, such as the TA6 form, which includes the property details, disputes, boundaries, planning permissions and guarantees. A TA7 form is if the property is a leasehold, including details of the service charge and ground rent. The TA10 form lists what is included in the sale, such as if the house is being sold without furniture or if the sale includes any furniture. A standard template for a contract of sale can be found online, but the templates are also customizable, so specific terms relating to the unique circumstances of your property transaction can be added in. Once the draft contract is complete, the seller's solicitor should send the contract and standard protocol forms to the buyer's solicitor as a contract pack, so the buyer can review them. The buyer can look over the contract and ask questions to the seller, known as making inquiries. The inquiry process involves communicating with the seller to negotiate all the terms in the contract if anything is unclear or if there is any further information that you need. Once the contract is accepted, the buyer should pay a deposit towards the house, which is usually 10% of the cost. This means that if the buyer backs out of the contract, then they lose the deposit. Or if the seller backs out of the contract, the buyer can take them to court for breaching the terms of the contract. To accept the contract of sale, both parties must sign identical copies of the contract, and the contract is exchanged between the parties. The contract of sale will contain a completion date, which is the date where the final transfer of the property happens. On the completion date, the buyer should pay the remaining balance on the house. After this, the buyer now has access to the house, being given the keys to the property. However, the buyer doesn't become the official legal owner of the property until they register the property in their name. The buyer's lawyer should do this by filing an AP1 form to update the property's registered title owner. The AP1 form should have a TR1 form attached to it when it is sent. A TR1 form is the official transfer deed used to transfer the ownership from the seller to the buyer. It must be completed and signed by the seller who sends it to the buyer. The TR1 form must be executed, meaning the seller's signature must be witnessed by an independent third party, which is usually the seller's solicitor, although the witness doesn't have to be a lawyer. If the buyer is using a mortgage to purchase the property, then a mortgage deed sent by the lender must also be registered. If the buyer is not a conveyancer, then to register the documents, they need to file an ID1 form to confirm their identity to HM Land Registry. The main document you send is the AP1 form, and this contains all the other documents. Once these documents have been sent to HM Land Registry, they will update the register and send the buyer an updated title register confirming legal ownership. During the time the buyer is preparing all the documents to send to HM Land Registry, the title register is vulnerable to claims from third parties. This is because before the buyer registers their ownership, they are not the legal owner of the property. So other individuals, such as beneficiaries, creditors, or lenders, can register an interest or charge over the property, which could take priority over the buyer's own registration. To prevent this, the buyer should file an OS1 search to confirm if there have been any alterations to the title register since its official copies were produced. Once the search is made, the buyer has priority over the register for 30 days, meaning third parties can't register an interest over the property. Finally, the property transaction could be subject to stamp duty land tax. Stamp duty land tax is a tax paid when you purchase a property. The tax is based on a percentage of the property's cost. Stamp duty land tax starts to apply when a house costs more than £250,000, or if the house costs more than £425,000 for first-time buyers. For commercial buildings, land or mixed-use properties, stamp duty land tax arises when the value of the land is above £150,000. To pay stamp duty land tax, you must first file an SDLT return to HMRC within a 14-day period after the completion date set out in your contract of sale. To file an SDLT return form, you must go onto the gov.uk website and log into your account. Then fill in the online stamp duty land tax return form. After filing your tax return, you will receive a stamp duty tax certificate or SDLT 5 form, which is proof of your payment. This certificate must be sent with your AP1 form to HM Land Registry if stamp duty land tax is required to be paid on your property. If you do not pay your stamp duty land tax within 14 days, then you will receive a fine as well as having to pay interest on every day you don't pay the tax. So in summary, to purchase a house in the UK, you need to agree to a price, complete the relevant title searches and property searches, review the contract of sale, exchange contracts, register the title of your property and pay any tax. If you found this video helpful, then you may want to check out other legal videos on my channel.